Just picture this. You apply for your green card, and what happens? Your residence. This is everything that you've been hoping for. You're expecting one of two things to happen: either gets approved or it gets denied, right?
Right. That's what everybody expects. Good news or bad news.
That's just it's very frustrating. Well, there's a third option now. Now that no one's talking about it, you get denied, and you get a court date in the same envelope.
So you're saying that instead of just a no, you could end up standing in front of an immigration judge?
Exactly. And that what you're going to get in the mail is called a notice to appear, an NTA for short. And that's what we're breaking down today. It's very important. Please pay attention to what we have to say today.
All right, so break it down for us. This isn't a new law, right?
No. It's not a new law. It's USCIS changing how they handle denials. So back in February 2025, they said, if we deny your case and you don't have legal status at that moment, we can hand you a notice to appear right along with the denial.
So it's all about timing. So if your status has already expired and then they say no.
Exactly. And this hits green card applications and change of status applications, the I-485 or the I-539, the common stuff that people file every day. So this could very much affect you.
Right. And a lot of people we know file I-485, so legal permanent residence, I-539 for change of status, and also for even if they're changing status to a student visa. So that these two applications are very important. So now you said that there were two changes stacked on the top of each other.
Yes, that's right. Okay, so here's the second one. In May of 2026, recently, USCIS put out new guidance. It basically says that getting a green card from inside the United States, adjustment of status, isn't something you're entitled to. They've actually called it discretionary relief. It's like a favor, like a routine benefit.
So then,
it's not a routine benefit.
Right. So then the officer has a discretion to decide if the person can do the adjustment of status within the United States. So what does that actually mean for the average person applying, let's say, for adjustment of status or I-539?
That's essential. It means that officers are now told to really question you why you are adjusting your status here instead of going through your home country's embassy. And if you overstayed your visa before applying, that now is going to count against you even more heavily.
Wow, let's put this together. So what are we saying here?
It's harder to get approved, which means there are going to be more denials. And more denials for people without status means more notices to appear. And there's your domino effect. So,
Yeah, that's really, that's a big change. So, and is there anybody here who could be at risk? So give us something specific.
Yeah, let's be specific. Here at the top of the list, anyone who's out of status right now and has a pending application, also spouses and family members of U.S. citizens who don't currently have a valid status, those are the people at risk.
And what about people here on a work visa, like an O visa, R visa, H visa? What about those people?
If they couldn't keep their status while their case was pending, they're at risk too. And this is the part that people miss. Family members filing their own paperwork, like a spouse or a child on an I-539, aren't protected, even if the main applicant is an employment-based case.
Wow. So who is more protected then?
Mostly employment-based petition beneficiaries, the actual worker on the visa, for example. There's a narrow exception if that person also signed the petition as a business owner. But generally, that group has more protection than family-based applicants. But this is not easy stuff. So, listen, watch this over and over again. You'll get it, but be protected. That's what we're here for. We don't want you to get in trouble. We want you to stay protected.
Right. We're trying to make it a little bit clearer because there have been so many changes, daily changes.
Yes.
And so what I want to make clear to our audience is that getting an NTA doesn't mean that you're automatically getting deported right away, right?
No, right. Okay, that's a good thing. Okay, the NTA, but this is important to listen to this because the NTA starts a court process. You still get a hearing date. You still fight for your case. And there may still be relief available to you. But these are serious times. It's not a final answer. So what should people actually do?
Right. So then let's talk about what somebody should actually do before they even file.
Well, get your case looked at by an attorney. I always say this because it really is important.
Yeah.
Before you file your taxes, give it to an accountant. Before you get your surgery, go to a doctor. Okay?
Right.
So before you submit anything, check it out with an immigration attorney with a lot of experience, please. Especially if your status is already lapsed. Don't just self-file and hope for the best, like a lot of people do. Don't do that, please. Now you're being warned. We're telling you now. You don't have to do that.
And be honest on the application. You need to fill out the application with the honest answers.
Of course,
and honest. We don't like to say be honest, but
right.
What do you think?
Say it anyway. Okay. Any kind of misrepresentation is a huge red flag under this policy. Full, accurate disclosure every time. They're going to find out, and then you're going to have a problem.
And what if somebody already filed and you're just waiting right now?
Well, know exactly what your status is today, not what you think it is or what you would like it to be someday. And start gathering your documentation now. So what are your family ties? Hardship, reasons for adjusting your status here. And you had a reason for adjusting here. Remember them. That's exactly what the officers are being told to weigh.
And if someone already has an NT in their hand, what's step one?
Don't ignore it. Don't throw it away. Don't not do anything about it. Please don't do that.
Mm-hmm.
Do not miss that first court date, the master calendar hearing. It is vital. Missing it can get you an automatic removal order. That means deported. You get an attorney immediately. This is a court case now, not a mailbox situation. I see too many people at court. I go to court all the time with no representation. They have no idea what's happening. They have no idea what's going to go on. They don't know what they're going to apply. Don't do that. Please, guys, don't do that.
So then for everyone watching, what would we say? A denial is what?
Denial isn't a denial anymore if your status isn't secure. That letter can come with a court date attached, which gives you a chance. So timing and preparation matter more than they ever have. Watch the mail. If you change your address, make sure everybody knows about it.
So if you think about applying or you're already in process and you're not 100% sure where your status stands, don't guess. Get your case reviewed, okay?
Always get your case reviewed. Trust your attorney. Trust. Drop your questions in the comments, okay? We'll answer as many as we possibly can. You will even answer them right now. If you have questions, come on, guys. Get it out to us. We'll try to answer them for you, okay?
Right. And so remember that everybody's situation is different. Everybody has a different situation. So don't look at your friend, don't look at your neighbor and say, oh, wow, his case said this, therefore I should be able to do this. So, remember now, so February of last year was when USCIS started issuing notice to appears together with denial notices. And then May of this year is when USCIS said that they can treat adjustment of status. Sneeze.
Adjustment of status.
Sorry, guys. Yeah.
As, what were you going to say?
Yeah, just, USCIS can treat the adjustment of status application, on a case-by-case basis, but also very discretionary. The officer has the right to say, okay, you can do your case here or you have to do it outside. So you know what? I think I'm going to take some questions. And I also think that some questions arrived today. And Kellyanne has some questions for us.
Kellyanne is a very special young lady. Okay, she's our daughter. Okay, yes, she's a pain, but she's very smart. And she's going to ask some questions.
So she has some questions.
All day today. And I'll tell you something. Today, just so you know, in Miami, I saw in my car, it was 112 degrees. I've never seen such a high number. 112 degrees Fahrenheit.
Yeah.
And Kellyanne was the coolest room in the office today was in my room. So Kellyanne decided to sit next to me. So she made my area even warmer than it normally is. But she's going to make up for it by giving us some really good questions that she found today. She knows about today. And she's going to tell us about it.
Questions that arrived in the office.
Okay, why don't you sit here? Is that okay? You want to sit here? Okay. She's sitting here today, and I was sitting here, and all of her heat is coming my direction. So please, we'll let her sit here.
So I see that Louisa joined. Hi, Louisa. How are you? Nice to see you.
Awesome.
And we see Deep, who is always here. And Suhas, thank you for coming. And Sarthak is also here. And we're just so happy to see you and happy that you're here. Remember, if you have any questions, just write them in the comments, and we'll try to answer your questions, right?
Because everybody coming from TikTok and Instagram. So again, welcome. We're so happy you're here. And we're going to go over some questions.
All right. So some questions arrived today in the office. And I think you have them. So
yes.
Do you want to tell us what questions are? The questions are?
Yeah. So some of the questions we had included, I applied for a U visa and received an NTA in the mail. No denial. What can I do?
Okay, all right. So that's important. Okay, so a lot of people apply for different kinds of visas. So a U visa is a visa that the government allows you to apply for. It's in the law. If you're a victim of violence, domestic violence, violence on the street, violence in at the workplace, violence in a restaurant, violence anywhere. So this person applied for a U visa, and for whatever reason, it was denied. But I think this person was saying that they didn't even get a denial in the mail. All they got was an NTA, and we've been talking about the NTA. The NTA is that document that has the charges on it, and with that document, you have to go to court. So you have to go to court. You have to go to court. And what you have to do, don't ignore it. Don't say, well, you know what, I don't have my denial, so I don't know what to do. Work on the court case. You need to go to court. You need to present your case before the immigration judge. And maybe you can even renew your U visa before the immigration judge. But please don't ignore it. Don't just wait for the denial. Act on the NTA. The NTA is going to have the date of your hearing. Sometimes the date of the hearing will come later, but please be very vigilant if you get an NTA.
Yes. And another question we had was, I applied for a Cuban adjustment and received an NTA in the mail. What can I do?
Same kind of situation. So the Cuban adjustment means that that person applied for residence. That person is from Cuba, and that person was came in with a visa, and that person applied for under the Cuban Adjustment Act, applied for the residence under the Cuban Adjustment Act. So if you receive an NTA, again, I want to tell you again and again, if you receive an NTA, you didn't get a denial in the mail, you still have to appear before the immigration court. I remember that these people who are, asking us these questions, I remember they saying, well, I didn't get a denial, so I don't see why I should go to court. But you have to go to court. You have to obey the NTA, obey what the court is telling you to do, appear at your hearing.
Yes.
Okay, what's the other question you got?
Another question was, I applied for my husband 2 years ago, and the case is still pending. Is that normal?
Okay, so this person is saying that they're a US citizen, and they applied for the residence 2 years. Yes, that's totally normal.
Mm-hmm.
Normally, I would tell you that that's a long time. Maybe a few years ago, I would say, gee, that's a long time. But now it's normal. It's normal that a case can be pending for that long. If it's just an I-130 petition, it can take that long. When you file an I-130 and an I-485 application, sometimes it's a little bit faster, but not everybody qualifies to do that. So if you applied for an I-130, it's still pending. So hang in there. It's going to get adjudicated. It's going to get processed, but you just have to hang in there.
Yes. Another question we had was, I applied for my son, and he wanted an interview in India, but not live in the USA, and the embassy denied him. What can I do? Do I need to move to the USA? Okay,
so I get that this was a mom, and she applied for her son, and the mom lives in India. She applied for her son, and they went to the interview together at the American Embassy in India. But because she's not living in the US, and she's a petitioner, right? So she's not living in the US, she lives in India, the embassy denied the residence application. So this is what happens, guys. If you're a petitioner, okay, and you're applying for someone, you need to be living in the United States. If you're not living in the United States, the petition is going to be denied. Okay, that's just the law. The petitioner needs to live in the United States, needs to be working, needs to have a residence here, needs to have ties with the community, with the city, with the house, and so that's important. So if we don't have that situation, and the petitioner is not living here, then yes, the case is going to be denied. So I think that the best thing to do would be for the petitioner to move here and work things out so that you can probably contact the embassy again. Sometimes the embassy gives you the chance to cure the problem. So cure the problem and contact the embassy again and say, listen, the petitioner, I'm living now in the United States. I have residence here. I'm working. I am doing whatever I need to do, and I want to continue with a petition for my son. I know it's a difficult case. I know that there are times when people can't live here because of one reason or the other. Mm-hmm. But if you are going to petition for someone and you're a U.S. citizen, you must reside. You must live in the United States. Okay. I just want to see if we have any more questions.
Yes. anybody has questions, please put into the chat, and we can check over here too.
All right. So if you listen, guys, I know that these are some really tough times, and a lot of people are getting court hearings. A lot of people are people who have asylum applications, residence applications. They're getting court hearings, and remember that you have the opportunity. That doesn't mean automatic deportation. That you have the opportunity to go before a judge and plead your case. All right. So if you have any more questions, let us know. We'll be here tomorrow. We'll answer more questions for you. We'll give you more information, and you don't want to miss or miss out on the information because the laws are changing every single day. But we'll be here for you tomorrow. Goodbye.
Bye, guys.
And if you think Karlene did a good job, please let us know. Do you think she did a good job?
Yeah, she did a great job.
Let
You
us
guys
know,
did a good job.
please.